Now, this morning we welcome Tiaan Esterhuyse, one of the directors there at STBB, on air, and we're talking about understanding mortgage bonds and transactions when buying property. Tiaan, good morning.
Morning, Donnie, to you and your listeners, and thank you very much for the opportunity once again.
It's lovely to chat to you this morning. So buying a property, especially if it is your first time, is often an emotional and stressful experience. In the majority of these transaction purchases are dependent on registration of mortgage bonds, financing the purchase price, or a substantial part thereof in the transaction. Now, this morning I quickly just want to chat about this and really getting to the basic of it and frequently ask questions when you have to do with mortgage bonds. So let's start it off. What is a mortgage bond?
Yes, Donnie. So it is a big part of the property industry, and a creditor who advances money to a debtor usually requires that debtor to provide some form of security for the repayment of the debt. A borrower, or in legal terms and conveyancing terms, a mortgagor, can then offer his or her immovable property to a lender or mortgagee, and usually that is in the form of a bank, a security for repayment of that debt or loan. The mortgagee or bank will cause a mortgage bond to be registered over the immovable property as security for fulfillment of the borrower's obligations contained in the loan agreement that is agreed to between the parties.
Mm-hmm.
The bond enables the lender, in the event of non-fulfillment of the borrower's obligations, to have the property sold and to utilize the proceeds thereof to satisfy the claim against the mortgagor and the owner of the property. So a bond vests the mortgagee or the bank with a real right of security against the property of the mortgagor.
Oh, right. And I think it's so important to just know every step of this process and talking about the stages in this process. At what stage when buying immovable property does a mortgage bond become part of the process?
So when a purchaser's offer to buy certain immovable property is accepted by the owner or seller of that property, and the purchaser has to apply for a loan from a bank or financial institution to cover the full or part of the purchase price, the offer to purchase or deed of sale will include a suspensive condition whereby the agreement or contract is made subject to the purchaser successfully obtaining the loan amount or a loan amount from a bank or financial institution in the form of a mortgage bond to then be registered over the property simultaneously with transfer of ownership of that property to the purchaser. Usually, in terms of the provisions of the sale agreement, the purchaser will have a specified time frame within which the loan or bond must be granted. If it's approved in time, the suspensive condition is fulfilled and the agreement is valid and binding. But if the condition is not fulfilled timeously, the contract will lapse. A purchaser usually submits a copy of the complete deed of sale or sale agreement to the banks as one of many supporting documents as part of the application for the loan or bond.
Mm-hmm.
It can be submitted directly to the bank by the purchaser or with the assistance of a mortgage originator. And then once the bond is approved, the bank will appoint one of its panel attorneys to actually attend to registration of the bond at the deeds office.
Tiaan, then as a property owner, I definitely have rights and obligations. What are they?
So the owner or mortgagor must obviously repay the capital debt and interest to the mortgagee on the terms set out in the loan agreement.
Mm-hmm.
Repayments are usually scheduled over a 20 or 30-year term, depending on that specific loan agreement. The mortgagee or bank does not obtain rights of use and enjoyment of the mortgage property, as this right is retained by the registered owner of the property or the mortgagor. However, the mortgagee may place certain restrictions on the owner's rights. For example, that he may not, without the consent of the mortgagee or bank, grant something like a servitude to be registered over the property in favor of a third party.
That's quite interesting.
Now, going off that, who can mortgage a property?
So a mortgage bond can only be registered with the consent of the legal registered owner of the property. So a property held in joint ownership can be mortgaged only if all the co-owners give their consent and are registered as mortgagors. A person married out of community of property can mortgage his or her own immovable assets without spousal consent. But it's important to understand that if you are joint owners of immovable property, even if you are married out of community of property, both will have to be mortgagors. One of the spouses can't apply for a loan to the bank on his or her, or by him or herself. They will both have to be registered as mortgagors if they are co-owners. Okay. And then obviously in the event where spouses are married in community of property, one spouse may not mortgage the joint immovable asset without the other spouse's written consent.
Interesting. This morning in our legal insert, we're chatting to Tiaan Esterhuyse. He's one of the directors at STBB, and we're finding out a little bit more about mortgage bonds, the stages that you can go in, or the process, the rights and obligations, and we also chatted about who can mortgage a property just now. Now, Tiaan, just to dig into the deeds office, I want to find out why are they involved?
So the real right which is embodied in the mortgage bond is only conferred on the mortgagee or bank after the bond has been registered in the deeds office. To effect registration, a mortgage bond must be prepared by a conveyancer and lodged at the deeds office for registration. So that takes place when the bank instructs one of their panel attorneys to attend to that registration on its behalf. Mm-hmm. In practice, an endorsement is then made on the title deed of the property, which is mortgaged, which records the details of the bond registered over that property. Once that original title deed is then delivered to the conveyancer attending to the transfer of the property after a successful registration, the original title deed has to be submitted to the bond attorney and then via them to the bank securities department until such time as the bond is cancelled again in future.
Fantastic.
Okay, so here's the question that I think most of us shaking our boots about. What are the costs involved?
Yes.
It is a very important question because we often encounter purchasers who are surprised by the fees involved for not only taking transfer of the property but also for registration of the bond simultaneously with that transfer of the property into their names. So exactly like with the transfer process, there is a registration fee in respect of the bond to be registered. The fee is prescribed in accordance with the tariff recommended by the Legal Practice Council to be charged on the amount of the bond to be registered. So it's calculated on a sliding scale on the amount of the bond registered. In addition to that is a deeds office registration fee that's charged by the deeds office for registration of the bond. This is a set fee also determined by the amount of the bond, but this fee is included in the account that you will receive from the bond registration attorney, and they in turn will pay that over to the deeds office. Something to also just keep in mind is that most of the banks will charge an initiation fee prior to registration of the bond, and that can be payable to the bank upfront by the purchaser or capitalized and made for a part of the principal debt repayable to the bank.
Wonderful.
There's a monthly service fee payable to the bank, which is usually approximately 69 Rand. And then something else that has to be kept in mind is that there's a requirement for homeowners insurance to be in place prior to registration of the bond in terms of the requirements by the financial institutions. At this stage, I would like to mention that listeners are welcome to go and have a look at our app, STBB Direct app, that's available on Google Play or App Stores, where we have a very nice calculator that can give you the estimated bond registration fees immediately, and you can share that via many platforms. And it also makes provision for calculators in respect of bond repayments and also affordability to give you an idea of what amount you may qualify for prior to even thinking of going to the market.
That's excellent. So that is, you can just go on your own. Such a useful tool. Go to your App Store, Google Store, STBB Direct, and you'll find it, and you can know more exactly before you have to really enter into this mortgage bond. Tiaan, thanks a lot for chatting to us this morning. Director there at STBB, the big small firm, and they're located in Paardetvlei, Somerset West. If you want to contact them, 021-850-6400. Tiaan, have a lovely day.
Thank you very much. Same to you guys.
Cheers, bye-bye. En hierdie regskolom program was met trots aangebied deur STB prokureurs. Vir vooraanstaande regsadvies teen bekostigbare tariewe, skakel hulle om 021-850-6400. Dis waar jy vir Tiaan en sy span ook kan kry. Jy moet net onthou dat Radio Helderberg of STBB prokureurs nie aanspreeklik gehou kan word vir enige skadegely wat voortspruit uit advies gegee in hierdie regskolom program nie. Elke saak moet op sy eie meriete hanteer word.